In Florida, there are a few types of alimony, and the first and foremost is temporary alimony. This is what someone gets at the beginning of the divorce process to keep the status quo, make sure the bills are getting paid and the kids are fed and, private school tuition is paid for. So we may have to ask for temporary alimony in that kind of a situation. There's also durational alimony. This is the most common thing that you're going to hear about. This is where we look at, well, does someone need alimony? Does someone have the money to pay alimony? And how long were we married to determine how long I'm eligible to get it? So this is like payment for a period of time. There is no longer permanent alimony as a presumption in Florida. So just because you were married for 40 years doesn't mean you're going to get alimony for the rest of your life. There might be an argument for that, but it's not presumed. There's also a type called bridge the gap alimony. The max time you're going to get that, if you're eligible for it, is 2 years, and that's literally to help someone go from married life to single life and just make a transition. In other words, it might be higher for a 2-year period, and then it might get lower over time if you're going to durational. The most difficult type of alimony to prove that you have eligibility for, but you may need it, is rehabilitative alimony. This is where someone has perhaps been a stay-at-home parent, they haven't been in the workforce for a really long time, and they may need to go back to school or get some kind of other training in order to re-enter the workforce. This requires an actual plan that you present to the court, not just words. So you're going to need to work with your attorney to come up with a reasonable plan to get you what you need so that you can take care of yourself when you are out of this marriage. In the past several years, there have been some changes to Florida alimony rules or spousal support, which is a less conflict-driven word. The big one is there is no longer permanent alimony in Florida as a presumption. So can you qualify for that? Yes, you might qualify for it if the marriage is of a long duration and there are health needs, there are career issues, the age of the parties matters. There are a lot of factors that go into that. And so we weigh it. But for all intents and purposes, it's going to probably be durational alimony for a longer period of time is more likely going to be the scenario in that case. First and foremost, I want to say that the word alimony is a very charged word. So I'm going to call it spousal support. How does a judge decide whether or not spousal support is appropriate in a given divorce scenario? And the very first factor is there a need? Does one of the parties have an actual need, meaning they can't cover their own expenses on their own? Is there a need for that in the marriage? Yes or no? And then the second question is, does the other party have the ability to pay that difference, right? So we're looking at that. Then we're going to look at the duration of the marriage. In Florida, there are short, mid, and long-term marriages. The duration of the marriage also dictates how long you might be eligible for alimony or spousal support in this case. Then we calculate it based on your net incomes and what is the differential between the net incomes, and the max that you can get is 35% of that differential. In Florida, how long can you get alimony or how long do you have to pay it? If you've been married for a short period of time, then the max you can get, this is from 1 to 10 years. That's considered a short-term marriage. Then you're eligible, that's the max, for up to 50% of the time that you've been married. So 10 years equals 5 years. That's the max you can get. Then midterm marriages, which are 10 to 20 years, you are eligible for the max of 60% of the time that you were married. And if you were married for over 20 years, then you are eligible for up to 75% of the marriage. Remember, these are caps. Another thing that you want to think about is you may not want to receive alimony or spousal support or write that check out every month for the next 20 years. That might not be what you want to do. In that case, we have another form of alimony called lump sum alimony. And so we may want to, when we get to the equitable distribution table and we've figured all that out, we may want to come back and say, okay, let's look at alimony. What would we be paying over the course of the next 20 years? What is the present value of that amount of money? And what's the future value? And now let's figure that out. And so that is a way to eliminate the need to write the check every month, is to just pay it all at once up front. Some people will come to me and say, well, hey, we already got a divorce and he is making way more or she is making way more. I don't want to have to keep paying her alimony when she's making more than I am now. Can I modify that? The answer is really defined in your usually marital settlement agreement. If you have a marital settlement agreement that says after we pay this alimony, it cannot be modified ever, ever, never, ever. We are forever waiving the right to modify it. It can't be modified. So don't even try. If, however, that question was left open, yes, and the increase in salary by one party or the other, or decrease for that matter. So maybe someone no longer has the money to pay those alimony payments. You do have to go back to court, file a supplemental petition to modify the final judgment, and you're going to claim that that either increase or decrease in income is a substantial change in circumstances. If you cannot establish a substantial change in circumstances, there's no way to go back and modify that. For the most part, if there is not something in your marital settlement agreement that says that you may not modify alimony, that you're waiving the right to do that, you can, if somebody's income goes up or down.